Yes. Kindly see below feedback, contact, Marico, etc. Come number of servings per pack. Have you actually got that? Number of servings per pack 9. Serve size approximately 10 grams. Then logic show the bottom. It's not good. So then show this. 3 teaspoons full of each product provides approximately energy of so much, protein so much, carbohydrate so much, total fat so much, saturated oil, etc. My submission is all this will not be if I use it to the hair. And
leave
the last recommended.
Leave that. But the fact of the matter is all sold in cosmetic section.
No.
Yes.
No. But fortunately,
you don't go to the supermarket.
Well, I do go, but I do go. Of course, now we have got Blinkit and all that, but lots will kindly see. Recommended for dietary use. Now, I'm grateful because Supreme Court has said the fact that it is sold in this market or across the counter will not make a difference. I'll come to that also. So the point I'm making is, to conclude my arguments, as the Lordship rightly put it, the whole thing has been.
Don't go on this. It's the weaker footing. Your main strength of the matter is HSN code as it is. Coconut oil is to be classified.
So Justice Gogoi has laid emphasis on this. That's why I'm mentioning. What Justice Gogoi goes into it.
We need not. If we go into all that, then we are going into grey areas in the sense that then we are applying the common parlance test and other things, other issues are coming into picture. And you want to avoid that.
I'll avoid that. Can I just make one last submission and I'll pass on this point?
Because if we go by the end use test or common parlance test, you will be in difficulty.
Yeah, I'll come to it. But what I'm submitting is, I'm coming to common parlance later, but for the time being, my submission is, HSN mandates that suitability for use is only depending on the kind of labeling packing you do. So if you want to show it's a cosmetic, the labeling must indicate it is suitable for hair use, suitable for skin, suitable for this, etc. Now, this is the mandate of the HSN which we have followed in our parliament. So, I'm only submitting one additional point. As the Lordship rightly put it, this may not be the clinching point, but the additional point in my favor is, I make this under a food license. The plastic is of a different grade. I mark it as edible oil. And lastly, Murad, my labeling, and this is required by law, I am not doing it for saving on tax. The food regulation requires that every 100 ml, Lordship knows now about every 100 ml, what's the sugar content, what has to be indicated. So because I am a food, I have to indicate each and everything for one serving, what is the person. And lastly, recommended dietary allowance for adults per day is also mentioned. So once I'm following the food safety, it's one indication that it is a 15 item. Now, coming back to my note, before that, I'll just come to the Woodcraft decision on HSN. Please come to. This Bhanuvati refers to para 12 of a Woodcraft at para 113. But the more important paragraph is para 18. I'll come to that. Please come to para 12 here at page 791.
Para
113. Was the Woodcraft. The court held that HSN is a safe guide for interpretation. There also, they tried to see what is the meaning of this plywood, how is it commonly understood. The court rejects that. How can we see? It is significant, as expressly stated the statement of objects and reasons, that the central excise tariff are based on the HSN, and the internationally accepted nomenclature was taken to reduce disputes on account of tariff classification. Accordingly, for resolving any dispute related to tariff classification, a safe guide is the internationally accepted nomenclature emerging from the HSN. This being the expressly acknowledged basis of the structure of the central excise tariff in the Act and the tariff classification made therein. In case of any doubt, the HSN is a safe guide for ascertaining the true meaning of any expression used in the Act. The ISI glossary of terms has a different purpose, and therefore, the specific purpose of tariff classification, for which the internationally accepted nomenclature in HSN has been adopted for enacting a central excise tariff, must be preferred in the case of any difference between the meaning in the HSN and the meaning given in the glossary of ISI. So what they say is our own Indian standard specifications will take a back seat when compared to the HSS because intention is to align both together. Now, what is more important is para 18, which you will find in the compilation given by my friend at page 93. Compilation of page 1. From the first case in Jain exports, but I am coming to page 93. But this is also page
Page 93.
93, a bench of 3 judges. Now, para 18 is critical at page 103. First page got page para 18, page 103. And then 3, para 18.
Yes.
Yes. We are of the view
Para 18 of
Woodcraft. Judgment starts at page 93 at page 103. There, in the reverse way, SSC tried to rely on ISI. He said ISI will prevail, but the appeal to the revenue were allowed. Can Lordship see para 18?
what is the issue in this case? Plywood.
Yeah.
Linear panels.
Classification of blockboards and plywood. Yes. Lordship wants.
There is a difference being made between plywood and blockboard.
Yes. Please send to page 95 now. Page 95. That will highlight the dispute the court was concerned with. The main question for decision in these appeals and in the connected matters is that the blockboards are to be classified under heading 44.08. Subheading 4408.90 is claimed by the revenue, or heading 44.10, subheading 4410.90 as claimed by the manufacturers of blockboards. The controversy relates to 3 periods, etc. This is the main classification. Yes. Now, my lord, after extracting all that, then Lordship will kindly see the para 12 judges. Yes. Now, please come to para 18. Page 103.
Yes.
Yes. We are of the view that the tribunal as well as the High Court fell into the error of overlooking the fact that the structure of the central excise tariff is based on the internationally accepted nomenclature found in the HSN, and therefore any dispute related to taxation must, as far as possible, be resolved with reference to the nomenclature indicated by the HSN, unless there be an express different intention indicated by the Central Excise Tariff Act itself. The definition of a term in the ISI glossary, which has a different purpose, cannot, in case of conflict, override the clear indication of the meaning of an identical expression in the same context in the HSN. In the HSN, blockboard is included within the meaning of the expression similar laminated good in the same context of classification of blockboard. Since the Central Excise Tariff is enacted on the basis and pattern of HSN, the same expression used in the Act must, as far as practical, be construed to have the meaning which is expressly given to it in the HSN, where there is no indication in the Indian tariff of a different intention. In our opinion, expression similar laminated good in heading so and so, as is true from the beginning, must be construed to include within its blockboard all kinds, etc., etc. Then finally, yes, consequently, all appeals to the revenue are allowed, while appeals in SLP to the manufacturer are dismissed. But now this judgment is sort of attained the status of a locus classicus. Please come to my written submission at page 14. Lordship will just come to my note. Sorry.
Yes.
It's on page 14. Right. Suppose we come to Woodcraft. From page 14 to page 17, it has been consistently followed by everybody. And for Lordship just want, I made an analysis of it.
So these are the names of the judgments where it's been followed.
Followed, referred, etc. And out of that, it has been followed by the Supreme Court 4 times. It has been relied 6 times, referred.
Okay, fine. That's all. That's all.
What I'm saying is there is no view at all. So HSN is completely binding. Now that's it. Now, my lord, I come to the next point of common parlance test, and I have concluded. Lordship will kindly see. Now, please see my note. Because the learned judge refers to both common parlance and common usage, and it's both are conflated. Since it is a common usage, it's also a common parlance. They're actually 2 different terms, but let's assume that it is the same. Now, at the Lordship sees, Lord, at 2.1, I have mentioned, Lord, how honorable one learned judge has rejected the common parlance test and said that common parlance test has a limited role to play if the entry is clear. And I have already showed last time, I won't repeat that entry 1503 is coconut oil of all kinds. It says coconut oil, palm kernel oil, babusa oil, which is a coconut kind of tree in Brazil, all come under 1503 unless they are chemically modified. Not only coconut oil, palm kernel oil, but babusa oil. Fractions of these oil also are coming under 1503. So once it is fully coming under 1503, just because it is used as a hair oil makes no difference. And just for ready reference, I have taken the page of my note at page 10. Lordship rightly pointed out that hair oil could be mustard oil, any other oil, not necessarily coconut oil. But I've just, there's a very good search engine from publicity.ai. It is one layer above ChatGPT-4. And there, yes, but it is now used extensively in courts as well, perplexity.ai. And there, I put a search, what are the uses of coconut oil? And this is the output I have got. So I have indicated the source, and the advantage of perplexity is that they give you the source of where they are referring to, which may not be there in ChatGPT-4. Now kindly see, coconut oil is renowned for its versatility and numerous applications across health, beauty, and culinary domains. Here are some of the key uses of coconut oil based on recent finding. I want health uses are given out. And kindly see at the bottom, hair care. Use as a conditioner or hair mask, coconut oil can reduce dandruff, soften frizz, restore moisture dry. Its unique composition allows it to penetrate hair better than many other oils. The culinary uses for cooking, beauty and personal care, additional applications, coconut oil's diverse applications make it a valuable addition to both personal care routines and will our moderation advisory to high standard of fat content when consumed. Now, in that same context, we see HSN notes which are given on the use of coconut oil, which is at page 31. Sorry, page 55. 42.
Page 42 or what?
Of this compilation of all the. So what is mentioned in perplexity?
What compilation is this? Which compilation?
This Bagada's compilation of all the times. My apologies, the Lordship.
42.
42. Now this is coconut oil. Coconut oil, copra, palm kernel oil, or bagasso oil, and fractions thereof, whether not refined but not identical wording. We have made this subheadings are slightly more put preparation for here. Now kindly see. Coconut oil. This is obtained from dried flesh of copra, as it is called, of the coconut so and so. Fresh coconut flesh can also be used. This non-drying oil is pale yellow or colorless and solid below 25 degrees Celsius. Coconut oil is used in soaps, cosmetics, or toilet preparations for making lubricating greases, synthetic detergents, laundering or cleaning preparation, and as a source of fatty acids, fatty alcohol, and methyl esters. Refined coconut oil is edible and is used for food products such as margarine, dietary supplements. So what is mentioned in perplexity is also confirmed by the HSN, which is there for the last 30-40 years. Therefore, my submission is the learned judge is in error by placing extra emphasis on suitability for use and packing in containers. Suitability for use has to be
This is part of what
explanatory notes of HSN.
this is a part of the explanatory.
Yes,
note.
which is now part of our, it is binding if the entry is the same. So my humble submission is suitability for use. If your lordship reads the explanatory notes to chapter note 3 I just read, the labeling must show it is meant for cosmetic, hair oil, etc. So suitability is not enough.
No,
Plus
in this case, it's not suitability. They've laid more emphasis on the packaging and labeling aspect.
Yeah, no, the learned judge keeps on saying it is suitable.
No. Your
Yes.
your argument
Yes.
is it's the label which is
Because both are combined. It should be suitable and the label, not just
which is this does not apply the suitability or the use test. It applies the labeling test here.
So I'll put slightly differently. HSN says suitability will be relevant only is in bold. Only the backing also indicates what it is used for. That's at page 55. So if I were to be classified under chapter 33 as a cosmetic, if I were to go under chapter 33, then kindly come to page 55. Preparations and unmixed products, etc., which are suitable for other uses, in addition to those described above, are classified in these headings, that is, in headings of what? Of chapter 33. Only when they are in packings of a kind sold to the consumer and put up with labels, literature, or other indications that they are for use as perfumery, cosmetic, or toilet preparations, or other group deodorizers.
In fact, suitable for other uses
Yes.
means they accept that the products may be used for other purposes.
But unless you satisfy that labeling test, it will not be. And that's why I mentioned about that labeling in my case, because of my food regulations, I have to show my
Okay, that's all.
That's all.
Let's
Now,
say, Mr.
common parlance test or this.
Not required. Let's see.
Can I please show the judgments?
You are saying common parlance test will
No,
not.
I want to show that common parlance test, one thing, selling in a shop is irrelevant. How it is, what is critical is how it is labeled, how it is meant. I'll just, 4-5 minutes, I'll just run through the judgment and I'll solve it. Not for anything else. Well, I'll go through very quickly. I just read in BPL pharmaceuticals, it is Selsun shampoo. They said you only call it a shampoo. It is sold in shops. What is it? Then they said Selsun shampoo is selenium sulfide, where it is used for creating dandruff. And therefore they said, Selsun shampoo was classified. Well, just give me 10 minutes, I'll just run through the judgments and everything. Selsun shampoo was classified as medicinal under 30 and not as a shampoo under 33, which referred to preparation for use on hair, including shampoos. This was a medicated shampoo which had 2.5% selenium sulfate for treatment of dandruff. The Supreme Court referred to earlier classification, indication on the label, and its manufacture under a drug license, and held that it is classified as a medicine under 03003.19. Similarly, in Dabur India, Lal Dai was held to be a medicine under Chapter 30. This was based on a drug license, and ingredients were mentioned in the Ayurvedic test. Then Woodcraft Life Sciences, iodine cleansing solution USP and Vocodine, USP is United States Pharmacopoeia, and Vocodine surgical scrubs were all classified under medicine under 3003 and not as detergent under heading so and so. Once again, the court referred to packing, labeling, and relevant ingredients. But here, what should happen is these scrubs were used for cleaning the operation theatre, etc. They said it's like a detergent. They said no, because of labeling, packing, and the ingredients. Now come to ICPA. surgical scrubs used as a skin disinfectant and wound disinfectant before surgery, and another scrub used by surgeons for rapid hand disinfection prior to surgery were also classified as medicament and not and under subheading 1303 and not disinfectants. But the department said you are calling it as a wound disinfectant, you are calling it as a disinfectant, therefore I'll put it there. They said no. You may refer it as a disinfectant, but what is its main function? The function is for using it before surgery to prevent any infection for the patient. Now, can we come to Ishan search? But Ishan is important. Possible, I'll give the xerox of. Ishan refers to 19 earlier judgments. Complete discussion of case law. In Ishan laboratory, it was held that the products in dispute were Ayurvedic medicine and not cosmetics. Rejecting the common parlance test, it was held that the common parlance test was not the be-all and end-all. The court took into account the labeling of the product, which has medicinal ingredients and was sold as Ayurvedic medicine. The last judgment is the latest one, which is very interesting. In uni product, they were selling car mats. Lots of know when you got a car, we got a car mat which we keep below the feet, near the clutch and the accelerator. The claim was it is a mat or textile floor covering falling under chapter 57. Department said no, it is coming under 87. Parts and accessories of car, because the mat is meant for the car. It is structured in such a way it can fit under below the seat. The Honorable Supreme Court said the HSN says a carpet or a textile flooring will be excluded from 87, will continue to be under chapter 57. So based on the HSN, they said we are not going with a common parlance test. Once HSN says that this is the ingredient, it has to be under chapter 57. I just read it. Car mats were classified as carpets or textile floor coverings under chapter 57 and not as parts and accessories of cars under chapter 8. The HSN explicitly note specifically excluded carpets identifiable for use in motor cars from heading 8708 and place them under 5703. Therefore, it is not necessary to refer to common parlance test. On the basis of explanatory notes, the car mats are held to fall under chapter 57 and not parts and accessories. Then got rule 1 and 3 say I've already argued. Just 2 points I want to mention, bro. Roman 4 I've already argued. Just come to the submission which my friend made. Kindly come to Roman 6 at page 6. Bro, apart from the fundamental errors of suitability and this confusion between that our tariff has now somehow become different and HSN has been jettisoned, apart from that point, the learned judge has been some informative. Reliance was placed on some website assuming the same with Marico, para 77, even though it was pointed out by the SSC that it is not Marico's website, and this position has been accepted by the DGCI in letter dated 22807. That's already there part of the lower court proceedings. Secondly, trademark. Observe that trademark application was only made for hair oil, even though the factual position on record is that applications have been made for edible oil and hair oil. They come under two different entries in the trademark. It's also relevant that the trademark parachute has been registered for various other categories like dairy products, pickles, jellies, etc. Generally, the same is done to protect any competitive action with respect to trademark. Generally, they apply the trademark for a number of entities. In the present case, edible coconut oil is marketed only under the brand name Parachute. In addition to edible oil business, Marico has a separate portfolio of hair oil, which is sold under the brand name Parachute Advanced with variations such as aloe vera, jasmine, etc., on which duty is being paid as a hair oil. Respondents are paying duty of rupees 300 crores per annum in respect of such hair oils. The relevant chapter note 3 has been incorrectly reproduced in paragraph 74 of the judgment, as products should be put up in can by retail facilitating such use. In para 78, it is used stated that the product is packed in such a way it is usable for the purpose of hair oil. It has to be classified as hair oil. Clearly, expressions facilitating usable are not employed in chapter note 3 of chapter 33. Then she has rejected the summary under 15 summarily in para 62, 82, 83 without noting the legislative background and only on the basis of usage and common parlance test. Then what I have mentioned about the earlier, Salve may do that point because Sharp was supposed to argue that on the question that if it's a non-speaking order, what is the effect? So I mentioned that Justice Gogoi specifically says if it's a statutory civil appeal, even if it is non-speaking, it will be a merger. And finally, my lord, I have given where in earlier the circulars of the department are in favor of the SSC. I point that out. And lastly, but not at page 9, I mentioned that for BBD, all the judgments are on record. The board circular of 2009 was quashed. No appeal filed. You could not trace it. That coconut oil is chapter 15. Then Dabur India, chapter 15. Recon oil, chapter 15. So all my competitors are under chapter 15. And finally, my friends have taken the trouble of getting various products of edible coconut oil, which all have got nozzle. That is not a huge factor. It's all groundnut oil, mustard oil, chili oil. No. I'm saying that small packing nozzle is not a relevant factor. Keep it available.
May I, Malad? Yes, Malad. 3 quick points. If your Lordship turns back to the language of chapter note 3, and in Mr. Bagaria's compilation, it's page 24. And Malad, this argument is inspired from a judgment of your Lordships relating to alcohol, where Malad, your Lordships construed the constitutional entry. Suitable for use and for use are 2 very different expressions. There it was fit for human consumption, or is it for human consumption? Now, Malad, please see heading chapter note 3.
Yes.
It says headings 3303 to 07 apply to products whether or not mixed other than aqueous distillates and aqueous solutions suitable for use as goods. That's the first part. So first of all, it should be suitable for use. And now these are critical words. Put in packings of a kind sold by retail for such use, not suitable for use. So it's not that it's in a retail packing which can be used, but it is in a retail packing for such use. So if it is being sold in a retail packing for such use, not suitable for such use, but for such use. Now, my lord, if that is correct, then a lot of the controversy about whether HSN words which were earlier to be found in the progenitor of entry 33 now dropped, fall away. My submission, therefore, is I am selling it in a packing. Now, my lord, a question can arise because today, my lord, in a world where some of us eat, as they say, my lord, some of us eat anything which walks, crawls, flies, swims. Prawn is a crustacean, but it's food. A chicken is a bird, but it's food. A goat is a mammal, but it's food. So, my lord, we have multiple dimensions. And one of the purposes which the HSN serves, my lord, the word binding perhaps becomes a little misleading if one is careful of language. The purpose which HSN serves is that there are, in today's complex commercial world, my lord, there are products which are multiple. So it gives you an indication and it gives you an anchor. And if your lordships consider what is the meaning of packings of a kind sold by retail for such use, not suitable for such use, then, my lord, the old HSN and its continuance, and I'll tell my lord why I say its continuance, gives us at least a steer. And that is the steer which says that if it is in packing sold to the consumer and put up with labels, for example, literature or other indications that they are for use as perfumery. That's an indicia. It's not that if I sell a aftershave without a insert, it ceases to be an aftershave. Or put in a form clearly specialized to such use. Now, my lord, one can think of so many forms specialized to such use. One example which comes to mind, my lord, is alum. Alum is a chemical. At good old days, my lord, the barbers used to use it post-shave. You now get it like a roll-on. So that's a form special. All nail varnish put in small bottles, my lord. Acetone used for varnish removing. Comes in a small bottle with a brush. Nobody's giving it for chemical purpose. So, well, this is the let's put it at its lowest. This is the steer. So it tells us something which assists in interpreting the expression for such use. Now, there are one or two important factual aspects, therefore, which, my lord, I want your lordships to notice. Actual in the sense, some surrounding matters. There is, my lord, provision in the food standards legislation prior to 2011, post 2011. And your lordship will find that there is a compilation of legal provisions, my lord. I wonder if that's readily at hand.
Yes.
If your lordship sees, my lord, page 90 of that compilation.
Which compilation? Legal provisions, they're separately circulated.
I believe so, my lord.
Mr. Bagadia's compilation.
No, I believe it was separately given. Just give me a moment. Whose? No, I believe, Mr. There is a compilation of legal provisions, my lord. I think Mr. Bagadia gave it.
Same thing. Page 90.
Yes, my lord. Is at page 91, footer page 90s. It's a schedule 3.
Yes, schedule 3 is there.
We've been shown.
Correct, madam. This has been shown, and I just wanted to show my lord something. The following commodities shall be packed only in such quantities, weight, measure, or number as is specified in the entries against them. And if your lordship turn to page 92, this puts to bed the argument, my lord, that if it is more than 500 or less than 500. Because by law, it recognizes that edible oils can be packed in 50 grams, 100 grams, 200 grams, 500 grams, 1 kilo, 2 kilo, 3 kilo, 5 kilo. More important, my lord, and just for the record, my lord, nothing turns on it. This is issued under what is called the Edible Oils Packaging Regulation Order, which comes under the Essential Commodities Act. So just to give your lordship the lineage of this regulation.
Edible oil?
Edible Oils Packaging Regulation Order, 1998. I believe, my lord, there are copies readily available. I just wanted to show my lord something. And 1B defines edible oils. edible oils means vegetable oils and fats. It should be the C is a typo, but does not include any margarine, vanaspati, bakery, etc. So it means vegetable oils. And if your lordship sees, just to complete the loop on this, Regulation 3. Prohibition as to sale on and from 15 December 98, no person shall sell or expose for sale, etc., etc. And B, which is not packed in a container, marked and labeled in a manner specified in Schedule 1. Now, this, my lord, requires, post 2011, we now have a more rigorous legal regime under the Food Safety Act. And if your lordships have that act, ready. Food Safety Act, I have. There's something I wanted to show, my lord, which is in this context interesting. Please see the definition of food in section 3J.
Yes.
It says food means substance intended for human consumption, not fit for. So, my lord, the law, whether it relates to packaging, labeling, and excise and imposition of excise duty, they all march in step. For use, intended for use, intended for human consumption, as against fit for human consumption. Now, if that is the test to be applied, then, my lord, we become obliged to comply with more rigorous standards. And we do. And that your lordship will find there is an IA for additional documents in which there is a tabular statement of comparative specifications for coconut oil.
No, that's correct. Mr. Salve, the Food Safety Act 3J may not help you much because then it goes to the question of intentment.
It is.
There, because whether it's intended for human consumption.
Yes.
Basically, then it will be going into, we'll be there, and we are dealing with a separate act.
No, so, my lord, I'm
Yeah,
so
just
sorry.
one-
I'm so sorry.
Because
Yes.
it is possible that coconut oil, even if we accept the argument of Mr. Bagadia and Mr. Dattar, coconut oil falls as, even if it's meant for as a hair oil, it will fall under the entry or HSN 15. Then also it may require, food certification if it is intended for human consumption as a edible.
I'm deeply obliged, my lord, for this question. In fact, that's the whole point. Please turn back to note 3 now. If your lordship see the language of note 3, if it is in packaging of a kind sold by retail for such use, and such use is cosmetic use. So, my lord, there must be something distinctive in the packaging which takes it out of the category of food.
Okay,
It may not cease to be.
Yes, your argument is the packaging itself must indicate it is intended for human.
It is for such use. Yes, not that it is fit for use as hair oil, but it is for use as hair oil. Because, my lord, today people there were, my lord, back in the day, milk, which is sold in milk bottles for as a food, is used as a cosmetic. cream, full fat cream, my lord. Today, I mean, people apply full fat cream, it's a skin softener. So we have so many, turmeric, my lord, which is sold today is considered a super drug, apart from being a superfood. So we have these areas of crossover. So when your lordship is considering an expressions such as packings of a kind sold by retail for such use, there must be something which pulls coconut, because your lordship has noticed, and I'm not wasting your time going over the same ground which has been traversed so much. Chapter 15 expressly mentions coconut oil. It's not that we are sort of generally putting it under facts meant for human consumption or something. It expressly mentions coconut oil. It gets pulled out of that chapter because the packing is so distinctive that it makes it a cosmetic. And if that is how your lordships read this entry, then HSN, the HSN problem, which is the second related point, gets resolved. And it gets resolved because there's one thing we have to always remember. It would be odd to suggest that Parliament amended the language of 33 to completely align it with HSN so as to disapply HSN explanatory notes. That's a that would be plainly wrong. If Parliament wanted to walk away from HSN, it would hardly have amended 33 to make it completely a replica of the HSN provisions. So, my lord, all that really doesn't get us too far. If one puts HSN in context, what does HSN tell us, my lord? HSN only tells us if you look at look for things like labels, literature, etc. Now, my lord, we have bottles, and post the change in the law, the bottles give, one of the bottles, which is the photograph is on record somewhere. It shows calorie content, it shows ingredients, which now you have to show. How much energy there is, and it is with reference to what is called the RDA, the recommended daily allowance. Now, if this is what it is, then, my lord, in my respectful submission, this change in law doesn't take you anywhere. That's my respectful submission for your lordship to consider. And what really we are concerned is, first, because we start with the language of head note 3 as we find it today. And then we see how it marries with the past. So if, my lord, one construes it on its strict literal interpretation, packing for such use in the manner in which I have, my lord, suggested it should, then a lot of this falls away. And yes, of course, my lord, we have had vacillations, the board first saying yes, then saying no, then saying yes, then saying no. Not too much turns on that, because ultimately your lordship is, if your lordships on a reading find that what the board said was completely wrong.
Legal finding, which
it must, yeah, it must. My lord, there is one last thing. I just wanted to show your lordship the photograph. And it is in one of the paper books. There's an additional compilation, my lord.
The photograph of the bottle?
Yes, my lord. It gives, after the change in the law. So I agree it's post change in the law, because this requires you to do, it's exactly the same bottle, that blue bottle. But now it also gives the calorie count, serving size. I mean, not something which is a serving size means it is intended not for use. You may use it, but it is not intended for use primarily as a cosmetic. And finally, my lord, we have licenses under the Food Safety Act, my lord, which we have put in our additional compilation, where we are shown as repackers of vegetable oil and processing units. Yes. That's, my lord, in my submission, at the end of the day, my lord, although we've taken quite some time, at the end of the day, it's a very narrow issue.
Yes.
It's a question of how your lordship read that
Yes.
note 3. The two notes side by side, this way or that way.
What has been highlighted, I don't know whether you got the full, what has been highlighted, the change and
My lord,
amendment.
may I be excused, my lord?
Support income which is in line. I'll answer that.
But I think statement will not, statement will not, nobody is not. According to point of view, for Mr. Salve point of view,
You are paying for?
there is a company called Index Port, which was subsidiary of Hindustan Unilever. That very product, eventually that company was sold to Marico, Mr. Lastman. This hour is only concerned for 2004-5. All other years have been classified as edible oil. For these 2 years, the assessing officer classified us as coconut edible oil. But the revisionary authority said, no, it should be hair oil, which was upheld by the tribunal by prepared the revisional order, in which an affidavit of a doctor called Mr. Ketan Bugir was pointed out, in which he points out that under the EFA for the relevant period, there is a different standard for coconut oil as raw material for cosmetic preparation, toilet preparations, versus coconut oil against. And the affidavit can give 26 parameters why it is different under the EFA, and the relevant standard is EIS standard 542/1968. And
For hair oil also, there is a different standard.
There are very different standards, which tribunal reproduces this, and then tribunal reproduces the product.
But that's fact specific then. In your case, that's fact specific.
It's a state matter and not appearing.
No, but it's a state back matter.
It's the Batman.
It's a back matter, not an excise matter. I'm not aware of that.
No, but then the classification in the VAT will maybe different from HSN. So we can't club it together. The state of Gujarat is here. No place. HSN is not replicated in the VAT.
Last time state of Gujarat appeared, they are saying they are adopting the submission of the state government.
No, but they can't.
That's what the council not having.
They can't. For a simple reason, the entries are different.
Different and HSN don't apply there.
The HSN will not apply there. They may like to cut it short because of various reasons. We'll have to detag it. We may have to detag that because we may dismiss it only then on the ground of facts.
Yes.
Because in your case, you relied upon an affidavit of a chemical analysis.
Yes.
Who says that this is not hair oil, this is meant for what were you selling, under which name were you selling that?
Same Bihar, same product, which was ultimately sold.
Bihar.
Yeah.
Bihar is meant for hair.
For that very period, we were also making perfume scented.
Fine, but let them come. We'll see them because your entries are different. We'll have to detag that completely. What is the item number?
101.2.
101.2 detag as it relates to provisions of the State Value Added Tax Act.
But I have only one request. How much? Put down up to one, I cover plus one. Two o'clock, Lord.
You try and finish. You're in rejoinder.
I know, but where I mean, I may need 30-40 minutes. The reason is
30-40 minutes.
I'll give the reason. Well, you will see now. This is what I'll tell you the conclusion. See how they capitalize the amendment. And so far, at least, I was under the impression we should confine it to the normal period of limitation. Package it in such a way, use that very entry, manipulate it, and go and sell it in the hair oil market. We want the demand to be now confirmed at an extended period of limitation, going by their own argument. I'll sustain it how? But it's a very serious breach. No bona fides. What you go and sell, because their own statements, which is recorded part of the judgment. I have 60% oil market. I have 70% oil market. This is for hair oil. This is all this I'm going to read from the very judgment, which has been. So you choose the market, you target your market, you go for hair application and camouflage it and say that, look here, a literature, misleading literature is also a literature of violation under the HSN. That's going to be an argument which I face in the bench trial. So it's a very serious breach. Please confirm it under extended period, not under normal period. But if I take, the reason is only this. 2 o'clock, this court, based on this court's direction, my lord, one implant has fixed on, my lord, one gas assert in Brazil, which, my lord, Union Cabinet has cleared, somebody's trying to us. I need to be there tomorrow morning. But I'll try to do what best is possible within 20 minutes. But please see, I'll go by Mr. Bagadia's set and see the entry. we'll go by his set, this slender compilation, which has the HSF, the old and the new regime. Please go to the old regime. Prior to 28 to 2005. Which is brought at page 5. Chapter 15, my lord, chapter 15, 1E, exclusion remains the same. There's no difficulty. So 15 excludes cosmetic and toilet preparations, sulfonated oils, and other goods of section 6. So this is a case where you can have products more than or beyond 15. So section note therefore cautions in 1E, something which can fall in 15, if it is in the nature of cosmetic or toilet preparations, will go to 33. So it's not that everything is bucketed only in 15 as an isolated, self-contained, unmanageable, non-exclusive, all that word doesn't sell. 1E is an answer to that. This 1E remains both under the old regime and also now I'll show the new regime. Your lordship saw 1E in the old regime. Please come to the new regime, which is post 2005. Please come to page 16.
But let's be very clear. Under the old regime, you are not taxing it as hair oil.
Yes, because the literature part was not, we couldn't answer it. Now we are suitable to use, we are taxing it under the new regime. And
so let's be very clear. Under the old regime, you never tax it as hair oil. Because though under the old regime, the cosmetics was
still available under 33. Well, I have to say that. It's a fact. So please come to 60. Please come to 60. Even under new regime, chapter 50 excludes under 1E cosmetic and toilet preparations. So first, now we'll go to the next comparison. Then I will not entry level. Please come to the old entry. Which your lordship will get it at page 6. This was the old entry. Fixed vegetable oils other than those of heading 15.0. Now please come to the new heading because they say that this is the difference. Please come to the new heading, which is at page 90. There's a specific heading for coconut oil, 1530. Page 90, coconut, copra, palm kernel oil, babazu oil, fractions, etc., etc. So, my lord, there is a specific entry for crude oil, others, etc. So, my lord, 15, 13, 11 and 15, 13, 19 relates to coconut. So, that's a specific entry. But nevertheless, 1E still operates. Whether it is a shrunk 1503 or an expanded 1513, 1E will still operate under 33. That has not been deleted. That's the first point I wanted to do. Now, please come to the second one. Now we go to old entry note, section 6. Old section 6, my lord. Section 6 note is at page 11.
Yes.
Your lordship will see only two notes. Note 1 and note 2 in section 6. Yes. Prior to 28 to 2005.
Yes.
Now you see the amendment. There's a new insertion which is in aligned with HSN according to them, which I agree. Please come to section 6.
Page number
23. Now you have a new note 2 post 28 2005, section note 2 in section 6. Subject to note 1 above, goods classifiable in heading 3004, 5, 6, 7, 12, 0, etc., etc., by reason of being put up in measured doses or for retail sale or to be classified in those headings and in no other heading of this schedule. It's a new insertion. So 1E is one. That is the difference between why we started to mention it to 33. 1E is one exclusion point. Now post 28 to 2005, the second important point, inclusion point is section note divides under note 2 by reason of being put in measured doses or for retail sale ought to be classified in those headings and in no other headings of the sheet. This is a new insertion. Now we go to the chapter level in 33, old and new. Please come to the old. Old is at page 12.
Yes.
Heading 3303 to 3307 apply inter alia to products whether or not mixed other than aqueous distillates or aqueous solutions of essential oil suitable for use as goods of these headings and put up in packaging with labels, literature or indications that they are for use as cosmetics or preparations or put up in a form clearly specialized to such use and includes products whether or not they contain subsidiary pharmaceutical or antiseptic constituents or held out as having subsidiary curative or prophylactic. This labels, literature, Malad is a part imported from the explanatory notes. You'll have to. The portion of the explanatory notes of HSN which indicates what are the criteria. 3A condition is part of. This is how it read earlier. Now see the new note. New note, Malad, is at page 24.
Yes.
Headings 3303 to 3307 apply inter alia to products whether or not mixed other than aqueous distillates and aqueous solutions of essential oil. Please see that this has splitting of suitable there and suitable not there. Please see the language. Suitable for use as goods of these headings. So you find suitability first for the heading. And put up in package of a kind sold by retail for such use. It is again suitable only. Now you find the suitability to the entry and abandon suitability for use. Suitability has to travel for the whole length. So not the splitting, saying that suitability is for the heading and not suitability for actual blood, I don't see it. So what needs to be proved, shown is if they are suitable for use or as specified, suitable for use in headings. Are they suitable for hair? 100% they all concede they can be used as a hair oil. Nobody can dispute it. No one has ever not challenged this blue bottle. It's incapable of being used as a hair oil. That's never their case. Not once. Anywhere. Including this court. So the test now, in terms of HSN, let's go by HSN, Woodcraft, everything. We are going to be. So the test is suitable for use as goods of these headings and put up in package of time sold by retail such goods. So these are the three. Last thing is not entry. Please come to old 3305 and the new 3305. These are the 4 stages.
Yes, which page?
But old 3305 is at 13.
Yes.
But this heading, the specific heading is very, very important. Preparations for use on the hair. Because HSN is slightly different. We can't simply say HSN Woodcraft will apply. HSN's, because not in HSN, they are all built-in culture. Outside India, hair oil is in very built-in culture. So, please see the entry prior and post. 3305 is preparations for use on the hair. Now go to the old entry. Now we'll go to the new amendment entry, which your lordship will get it at 28. Preparations for use on the hair. And specifically shampoos. And there's a specific entry 33059 3-hair oil. And makes a distinction. Sub-entry is very important. Post 2000, that was one of the reasons. It distinguishes between plain hair oil and perfumed hair oil. My friends are going on canvassing on preparation. I have a point there. I can understand, my lord, if perfumated hair oil alone is classified under 3305, they have a case. To say preparation can only be chemically reacted, chemically perfumed. So, please see The sub-entry in 3305 post to 28 to 2005 accommodates both perfumed and unperfumed. Very important. So plain coconut oil suitable for use in hair and not designed to be marketed in that way, which according to them considered several times in the judgment, which I'm going to read the paragraphs, is capable of being classified under, as per HSN. I don't want to argue different from HSN. As per HSN, will come here, not dual use. Then go by the guidance in the section note and chapter note is the cardinal principle of interpretation. And if you can't resolve, go to the interpretative rules. Dual use is always possible in tariff classification. We can't say, and dual use of the same product. Duality means what? Same. You can't say it should be processed. Process loses its character as duality, then it becomes duality. When there is an overlap, the cautions are threefold post 28 to 2005. One, if it is cosmetic and toilet, get out of 50, even though it is coconut oil. Section note 2, which was added in line with HSN for the first time, saying that if it is meant for retail use, take it to 33. And 3, the chapter note, which is in HSN,
You'll have to beat one argument. Look, the argument is this. There are two things which coconut oil is a separate classification. Everybody knew that coconut oil in India can be used for both edible oil purposes as well as for hair oil purposes. There's probably no data with regard to how much is used for hair oil or how much is used for edible oil. We don't have those figures.
But the High Court says, Delhi High Court years back, and the
No, maybe.
practices
No, that may not be.
marginal use in South
No, that's on the basis of self-assumption. In North India is different. In South India it will be different. Probably it will vary from state to state.
The Supreme Court judgment says it's generally used for both. Isn't it?
So let's not go into that. So the argument is that once coconut oil has been classified in this category, you will have to show, therefore coconut oil will be normally classified in this category. Knowing fully well, and if we say it's generally used for as a hair oil, then all the more, then why classify it under chapter 15? If it is most of the time it's used for as a hair oil, then don't classify it as a hair oil. Don't classify it as a 15. 2, the department also, the revenue itself also, always treated it before 2005 as under 15. So the department also followed that. Post also probably in some cases it's happened that.
we don't have any information at the moment. They say this, that.
No.
No,
but the fact of the matter is,
it's on record.
No. There are orders to the limited extent that SLPs have been dismissed. Appeals have been dismissed. No, please, Mr. Datta. Please, Mr. Datta. Not like this. So the argument is, even if it's a case of dual purpose, once coconut oil has been classified into 15, there is exclusion under 33. To bring it under 33, the onus then will be on the revenue and not on them.
Without doubt.
And in order to, and even the explanatory notes which were part earlier of the classification or this section itself, section notes itself, in fact, support them to the extent that earlier you were only going by the labeling aspect, correct? And therefore, when there is an issue of this nature, then keeping in view the earlier position adopted by the department, there has to be certainty and continuity.
Yes. But 3 things I straightaway agree. You have to start from 15, there is no doubt. Put everything under 50 and see whether something goes out of 50. Let's put that test. That's the onus which revenue has to satisfy, which I agree. That's not difficult. So coconut oil as a basic product will fall under 15. But now the chapter note under 1E of 15 says, if it is a cosmetic or a toilet preparation of this oil, it doesn't say processed, nothing. If the same oil has a utility as cosmetic and toilet preparation, then you will have to take it to section note 6. Take it out of, it is not that it is all encompassing at all points of page 51. 2. Post 2005. Section note 2, not chapter note. Section note.
There's difficulty in the first part itself. As far as our non-perfumed hair oil is concerned,
Yes.
there are number of products which can be used for hair oil, which are non-perfumed, but we can have,
Correct.
because Indians like to use hair oil or oil on their hair. And let us not forget, this tradition is far, far longer.
It has now been capitalized. But this is precisely our case.
It's far,
If I pay duty after using it as a, that's our case.
it's-
Traditions are far more time
And
ago.
at that time, initially, I doubted very much many of the oils will be perfumed because of the natural perfume in the oils itself.
Yeah. And many prefer that. Many prefer unperfumed oil.
Where many people may prefer unperfumed oil only because chemicals, obviously, people have reservations. We'll then continue tomorrow.
Tomorrow morning.
I got this one, but I want to just mention, Lord, apologies for interrupting, Lordship. What I wanted to mention was, Mr. Shamdevan was supposed to argue on the circular and the other cases. I thought Mr. Salve is going to continue that. In my note, there's an express circular classifying it as a chapter 15, reiterating in 2015. Then, my Lord, what happened? We had given a complete chart of cases where post 2005, in as many as 10 companies, they have dropped the proceedings, and as many as 13 job workers.
Just give this.
So,
Just give it to the
additional
solicitor.
11 show cause have been brought.
Okay, just give this details with these sorts.
Take your-